Welcome back to another explosive courtroom breakdown. Today, we're diving into a case that has everything: forbidden love, defiance of a judge's direct orders, family turmoil, and a courtroom packed with tension. The key player? A man who simply cannot let go of Scarlett Jones, the so-called love of his life, despite the fact that a judge told him in no uncertain terms, "Stay away." Now imagine this. You've already got an assault family violence charge on your record. The court is watching your every move. And instead of laying low, instead of proving you've changed, you violate the single most important rule: no contact. That's not just reckless. It's practically daring the judge to throw the book at you. What makes this even more intense is the web of relationships. The lawyers are literally talking about drawing out charts because the ties between people, in this case, are so messy, so intertwined, that even seasoned attorneys are struggling to keep it straight. Scarlett Jones, Sydney Jones, family ties, paramours, divorce drama. It's the kind of thing you'd expect out of a Netflix drama, not a courtroom docket. But here's the kicker. The judge isn't having any of it. She's laser-focused on one thing: why her no-contact orders are being ignored. And in a family violence case, emotions aren't excuses. This isn't about heartbreak or true love. It's about safety, the law, and consequences. So, here's my question to you before we dive deeper. If the court gives you one rule, just one, and you break it, do you think love is enough of a defense? Or should that kind of defiance always land you in prison? Drop your thoughts in the comments, because this is where the courtroom drama gets real.
So, is there a proposed agreement?
There is, Judge.
And what is the proposed agreement?
The proposed agreement, Your Honor, is for amending conditions for zero tolerance, house arrest for 30 days, GPS for the remainder of his term, extension for 1 year, and enroll in DIP within 15 days of release.
All right. And who is Scarlett Jones, and why is he contacting Scarlett Jones?
I can get a relationship chart for you, Your Honor. It's a little bit complicated within the...
Everyone, please whisper.
I can get you an answer, Judge. It's in the file. We literally had to draw this out across a couple of cases, Your Honor. Off the top of my head, I don't know, but I can get that information for you in the state's file.
All right. Is it Scarlett Jones or Sydney Jones?
It's, I believe, Sydney Scarlett Jones.
All right. And Scarlett Jones. Okay. The court ordered no contact with Scarlett Jones and Sydney Jones.
And Your Honor, may I ask a quick question? The counsel may know.
Yes.
Ruby, who is that?
No, Scarlett Jones is the person he pled true to the number 19 violation.
Yes.
And I ordered no contact with that person.
Understood.
So
Okay.
I want to know why my no contact orders are being violated. That's where we are. Does anyone want to address that?
Your Honor, this is unfortunately not an uncommon situation that happens when you've got parties that are getting divorced. You have paramours involved.
So was this contact made at a courthouse?
It wasn't made at a courthouse. It was not, Judge. From what my understanding is that he had gone by and he is struggling mentally to try to let go of what this relationship was. He misses his kids. He misses his wife. Unfortunately, she's moved on. What I can tell the court is that it appears that there was an application for a protective order filed, correct? My client has agreed to the entry of that protective order. It is a 5-year protective order.
But how old is he?
Who?
How old is your client?
How old is my client?
Yeah.
I would say probably like 40, 45.
All right. So I don't understand what he doesn't understand, that the court ordered a no contact.
Here's something crucial to understand. A 5-year protective order is no joke. This isn't just a piece of paper. It's legally binding, and breaking it can turn a slap-on-the-wrist violation into serious prison time. The defense is trying to frame this as a man struggling with emotions, but the judge is making it clear. Heartbreak is not a legal defense. Think about it. If every defendant in a domestic violence case could just say, "But I still love them," courts would collapse under chaos. What do you think? Should courts show compassion when love clouds judgment, or should the law treat it as black and white? An order broken is an order broken?
Order with Scarlett Jones. I mean, I know you all have your proposed agreement, but I don't know why I should follow this. I ordered no contact with Scarlett Jones. All of this nonsense about people not being able to let go. You can cry, when nobody's around, ask the gods, why am I not with this person? But I told him he couldn't be with her anymore.
Judge, I understand that, and I totally respect your position. Sometimes emotions get better at people, and I'm not saying that's an excuse, but I'm just I think that's the reality of what happened. Nobody was harmed. Nobody was, I don't believe in it. Nothing happened from the contact. We're trying to get this guy back on track.
Yeah. But this is what I want you to understand where I'm coming from. I ordered no contact with Scarlett Jones. I ordered no contact with Sydney Jones. This is an assault family second offense. And we probably wouldn't be here. And maybe you would still be in a relationship with them if we were not here for an assault family second offense. So I don't know why people tend to cause problems in relationships and then are shocked when somebody moves on and they don't want you anymore. So I don't know why I should follow your agreement when the main thing the court ordered was no contact. And this is a family violence case. And people don't want people showing up to their door because they've moved on and they don't want you anymore. I don't understand why people don't understand when people don't want to be with you anymore. It's like, I'm over, I'm done. I don't want you anymore. Why can't people internalize that?
I think he has. I think this time in jail has helped him do that. And Judge, if I had a reason for you to follow this, it would be to provide.
This is where the tension peaks. The judge is openly frustrated, and rightfully so. She's saying, look, relationships end. People move on. It happens. But when the court has already intervened because of violence, showing up at someone's house or violating no-contact terms isn't just emotional, it's threatening. Notice how she keeps hammering the point. I ordered no contact. Judges don't like being ignored, especially when safety is at stake. And here's the irony. If he had followed orders, maybe, just maybe, probation would still be on the table. Instead, the judge is questioning why she should show leniency at all. What do you think? Was the defense smart to argue for compassion, or should they have leaned harder into accountability?
Him the assistance that he needs to try and reform himself. I think the battery intervention program alone will do wonders for him. It will open his eyes as to what's going on here. And I also think that, like we said, he's been in jail for about 60 days now. He's going to have another 30 on house arrest. He's going to be on GPS. We can not only monitor him and protect the family, but he's got a protective order in place. I've already explained that to him, and this is for the record. I've explained to him that protective orders have teeth, and that if he violates that, it's not just an NTR next time. He's going to be back in here on a violation of a protective order.
Oh, but my rulings have teeth, and my ruling was
absolutely
there's to be no contact. What has he done on probation other than, get all caught up in his feelings going to somebody's house who doesn't want him anymore? Did he do anger management? Did you do anger management?
I rolled in the fifth. I did 5 of the fifth so far.
Probation, has he done anything?
Judge, he was granted probation in November. He submitted a negative delay in December. I don't have any indication that any of his classes have been complete. He did pay a total of $190 for his assessed fines and fees.
All right. Is there anything else?
No, Your Honor, and if the court would like to as well, like I said, not a state's file, like me creating a separate thing in a different file chart. I had to like draft out the relationships. It's like a whole page of who interacts with who. So if the court, if I could better explain, I would. I have that information. I don't have it with me. It wasn't.
Oh, no problem. The information I have is I ordered that he was not to have contact with Scarlett Jones. He's saying this is the love of his life. This is somebody he's willing to go to prison for, obviously, because he can't let her go. So I ordered no contact. This is an assault family second. He probably would still be in a relationship with her agreeing to be in a relationship with him if this wasn't an assault family second.
Judge, I understand completely where the court's coming from. I think that my client has had some time to, for lack of a better word, get it together. And I think that he can be successful in this. It's his first MTR. I'd ask the court, please, just allow him to complete these conditions. It's zero tolerance. Explain it to him. And if he comes back.
All right. The court is finding violation of condition number 19 true. The court is going to find him guilty. There's an affirmative finding of family violence. The court is not going to grant him probation. Would anybody wish?
And there it is. The hammer drops. The court finds violation of condition number 19 true, makes an affirmative finding of family violence, and denies probation. Translation, he's guilty. And the question isn't if he's going to prison, it's how long. This moment is pivotal. The defense scrambles for the minimum 2-year sentence, arguing no new violence occurred. Meanwhile, the state is pushing for 4 years. It's a classic tug of war, mitigation versus deterrence. The judge now has to decide what message to send, not just to this defendant, but to every future case where someone thinks they can ignore a no-contact order. Would you lean lighter, since no new physical harm was reported, or side with the EE state, arguing that ignoring orders is dangerous enough on its own?
Just speak to punishment.
Your Honor, I understand the court's ruling. I think given the facts and circumstances here, the fact that there's a protective order in place, and my client agreed to that protective order, he has moved on. I think that there is not any imminent danger to Ms. Jones or his family, and I don't see him going by there at all. We would ask, I know the court's got the full range of punishment. The court's not considering probation. We would ask for a minimum on this, a minimum of 2 years. This is not something where on this violation, anybody else was hurt. There's no other violence. And we just ask the court to consider the minimum on this case.
State.
And then, Your Honor, the state, about 10 seconds, Your Honor, the state is accessing the legacy system just to get a better handle on the Bear County criminal history, Your Honor. The state would respectfully request something in the range of about 4 years, Your Honor. And that is the state's recommendation.
All right. Court is going to find you guilty. There's an affirmative finding of family violence. Give you credit for any time served. There's to be no contact with Sydney Jones or Scarlett Jones. Court will sentence you to 4 years in the prison. All right.
So, here's where everything lands. The court sentences him to 4 years in prison. The defense's plea for 2 years falls short, and the judge makes it clear. This wasn't about punishing a man for loving someone. It was about respecting the law, protecting victims, and reinforcing that no-contact orders are absolute. This case is a stark reminder. In family violence matters, the court's patience is thin, and its responsibility to safeguard others comes first. The defendant's claim that Scarlett Jones is the love of his life didn't outweigh the risk, the history, or the violations. What do you think? Was 4 years fair, or should the judge have gone harder or easier? Drop your verdict in the comments below. And hey, if you found this breakdown as gripping as we did, hit that like button, share this video with a friend, and don't forget to subscribe for more jaw-dropping courtroom commentary. We've got plenty more cases that'll keep you on the edge of your seat.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and signed it?
Yes, ma'am.
All right. You have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I want you to know, I listened to the arguments of your counsel. I took that into consideration. And sometimes when the prison sentence that I give people think, oh, she's just doing that because the state requested it. There are different things that I'm thinking of in my mind to see what's an appropriate sentence for you. Do I think you deserve the full 10 years for contacting her when what your counsel has told me there was no violence perpetrated? No. So I wasn't going to send you to 10 years, but I don't think 2 years was appropriate for you either. You understand? All right. Good luck to you.